Good evening, everyone. Welcome to the second session of Winpe Ignite Masterclass Series 1. A message to those participants whose Zoom name is not on our list of registered participants. Please either update your Zoom ID to match the one you've used for registration, or in case you haven't registered, please use the link in the chat box to do so. We've shared it on the chat box. Okay, now we're ready to start. For those of you who don't know us, Winpe is a pioneering not-for-profit platform driving gender diversity in the investing ecosystem by increasing women's participation as investors, capital allocators, and recipients of investment capital. We work closely with PEVC firms in helping them shape and execute on DEI strategies, including hiring more women across roles and levels. When we launched in 2020 and we heard our member PEVC firms saying we want to hire women, but we can't find them, we were skeptical because we thought there were enough women keen on PEVC careers. In the last more than 4 years, Winpe has undertaken a number of initiatives aimed at supporting PEVC aspirants, including job bulletins, AMAs with industry leaders, boot camps with recruiters, and career fairs. Through these initiatives, we have also come to realize that the talent pipeline of women in PEVC is much thinner than we would like, and for various reasons. Ignite by Winpe is a platform designed to support the female talent pipeline in the private equity and venture capital industry. Ignite offers online career sessions, master classes, job vacancy information, and a profile bank of women interested in PEVC roles, accessible to member firms in an anonymized format. So when a PEVC firm hires, they can access our profile repository for candidates. The profile bank is open to women at all levels, including already in PEVC. And as I said before, we hide candidate and firm names in the database that is shared with hiring firms. Please join the Winpe Career Network WhatsApp group to join our profile repository. The WhatsApp group is also will also keep you updated on our sessions and with information on job openings, which we keep posting them there. I'm sharing the group link on the chat box. Today's session will be followed by a series of one more masterclass next Friday on the 28th. Now, before we move on to today, a reminder that if we do not find your name in the registration list, we will have no choice but to remove you from the webinar. So please either update your display name or fill out the registration form, and link is shared in the chat. Moving on to today, our topic for today is governance, navigating complexities of PEVC-backed companies. Introducing our trainer, Prerak Ved, partner at AZB Partners. With over 19 years of experience, he specializes across practices, including compliance and investigation, white-collar crime, corporate advisory, private equity, and mergers and acquisitions. A key member of the firm's compliance and investigation practice, he assists clients on internal investigations and white-collar crimes, defense, including fraud, bribery, and corruption, as well as on related disclosure and reporting requirements, liability mitigation, and regulatory investigations. Prerak's practice also includes all forms of M&A, private equity, corporate governance, and corporate advisory matters. Some housekeeping rules before we start. The session is being recorded and an edited version of the recording will be made available for future reference. You can type your questions anytime during the session at the Q&A section. Prerak will pick them up as and when or at the end of the session whenever. Now, without any further delay, let's get started. Over to you.
Thank you, Ankita. Thank you for having me here. Pleasure as always. And the purpose of your organization is indeed inspiration. So pleasure. So what I'll try and do, given the nature of the topic and the nature of the audience, is try and explain this I would say, the basic and the simplest possible form. I'm happy to address any questions on any complexities that come up in the topic. That's not an issue at all. But the idea is to explain the topic in 3 or 4 simple bullets. One is, what is the meaning of governance? Because that's ultimately what we are talking about here today. Second is, when you're talking of governance in PEVC companies, you're talking primarily in a PEVC context of nominee directors on company boards. So ultimately, if what are directors' duties and liabilities generally, if you are a director on the board of an Indian company? The third sort of theme that I run through is role of your nominee directors or of the investor directors on the boards of your investee companies, where the Ps or VCs have invested. And last is, what are the types of risks and liabilities faced by the members while being on the board, and what are some sensible mitigation strategies. So I think these are the 4 broad themes that I will cover as a part of this session. Happy to take any questions as the slides go, or as sort of the at the end. Ankita, you will be putting up the slide on the screen. Maybe
Yeah,
slide.
I'll just do
Slide.
that.
Thank you. Thank you. Can you go to the second slide, please, Ankita? Thank you. So effectively, just maybe 2 to 3 minutes on what is the meaning of governance. So when we talk about governance, it's a fairly loaded term. It's a fairly wide term. What does it generally mean, and what is the meaning of governance in context of the discussion that we are having? Uh, if one were to take a sort of broad brush, it involves basically doing the right thing in a given context, which is acting with transparency. This is not a definition that I've pulled out from any report. It's basically just a common sense set of principles that, at least based on my experience, I can talk to, which is, in a given set of circumstances, to act with integrity, transparency, honesty, and act in a transparent and a balanced manner, taking into account the interests of the stakeholders. And why do you need a governance? Like, what is this governance and why do you need it? Ultimately, the corporate form of organization, as all of you would be aware, involves a separation of ownership and management. And in some cases, ownership and management are the same, in which case these considerations are not as relevant. They are still relevant for external stakeholders like lenders and government authorities, but they become more relevant in context of this discussion today when the ownership and management are separate. Ultimately, it's about the accountability of the management in terms of how the company is run to the ownership, which is effectively the owners of the company, which may involve PEVC funds, the members of the management, third parties, etc., among others. Governance as a concept has actually evolved quite a bit. Believe it or not, our first sort of concerted push on governance in context of listed companies was your Kumar Mangalam Birla Committee report of 1999. And since then, there have been several of these reports, several changes in law and regulations, primarily governing listed companies, but there has been quietly leaps and bounds of change, including under the New Companies Act of 2013, not new anymore, it's 10 years old, more than 10 years old now, but effectively pursuant to the Companies Act of 2013 and additional sort of changes to that and other regulations. Effectively, there has been a lot of change in governance, even involving unlisted companies, startups, effectively any sort of corporate organization, mostly companies, but even LLPs and others. But again, we restrict our discussion to companies here primarily. Companies have actually now a much sort of larger set of governance canvas that they have to deal with. Now, the first question is, governance is it just compliance? You have to comply with 5 things. You have to file 5 forms. You have to hold 4 meetings a year. You have to do certain things. Is that governance? No, that is compliance. Compliance is actually very different from governance. And if you take a slightly more expanded definition, a very actually small part of what governance is. Governance is effectively how you govern the company's affairs, how you run the company's affairs as members of management, as members of board, as those who are entrusted with running the company's affairs, how they are run. That effectively was what governance is, and it's a lot more than sort of legal compliance. In terms of principles of governance, it ultimately rests on your each part of the management and the board doing their job. Effective oversight by the board, by that is the non-executive elements of the board, management cooperating with the board, giving the correct data to the board members for them to be able to take decisions, and all the other stakeholders within the company working together to be able to run the company or to be able to run the organization effectively and ethically. Now, I can give sort of a lot of other principles in terms of how governance should be, but I'm distilling it down to its essence. Ultimately, it's each stakeholder working honestly and in a transparent manner with the other to be able to achieve the commercial objectives of the organization. Benefits of effective governance. Actually, this is a topic that I wanted to spend a minute on, because ultimately everyone thinks of governance as, oh my God, there is so much of compliance, there is so much to be done, there is we need to hire people, we need to spend time and money on paperwork, we need to have all of these meetings, we can do other more productive things during this time. So why is it so important? Ultimately, governance, whether you believe it or not, has a, at least in my experience, a very, very strong economic impact. The quality of your governance in the medium to long term actually has a significant impact on the perception of your investors, perception of third-party investors, perception of other stakeholders, including the government, on the quality of your organization, and the benefits of that commercially are fairly huge. So if you think of governance as a chore, as something that, oh, I have to just comply, I have to just do these things, I have to just make sure that I do the bare minimum and I move on and focus on business, that is one approach. But at least to my mind, the correct approach is to actually focus on it as a part of business, as a business principle, while focusing on profitability, growth, and every other metric, to focus on governance, because the multiplier effect of getting it right are fairly substantial. I don't want to take names and I can't, but you yourself know in the listed universe today, there are some names of certain conglomerates which are inherently trusted. Why are they trusted? They are trusted because over the last decades, if not centuries, they have stood by their stakeholders, not just their shareholders. They have stood by their stakeholders and they have developed that legacy of trust. So ultimately, if you want to build an organization, it takes that level of trust and it takes that level of governance and that effort to be able to build it. So I think that is it as far as the first slide on governance. What does it mean? And to a large extent, why governance? Before we get into sort of navigating the complexities PEVC-backed companies for which we have the rest of the presentation. Ankita, we can move to the next. The next one is a brief introduction on directors' duties and liabilities. First question, why are we addressing directors' duties and liabilities before navigating the complexities at PE and VC-backed companies? Well, the reason for the complexities in PE and VC-backed companies is one, which I just explained in the first slide, which is the division between ownership and management. And second is the fact that if you are a nominee director or if you are a director on the board of a PE-backed or a VC-backed company, ultimately you have certain statutory liabilities to the government, not liabilities to other stakeholders, on account of being a director on the board of the company. Again, starting with the basics. Requirement for directors, role of a director. Why do you need a director? This goes again back to the discussion in the first slide that the corporate form of organization involves a division between ownership and management. And the management of the company reports into the board, which is as a legal matter across laws, including the Companies Act, but across laws, is ultimately responsible for the management of the company's affairs. So the directors are the bunch of individuals who have been given certain individual and collective responsibilities. As you can see, the third bullet, I'll touch on that briefly, but who have been given a bunch of responsibilities in relation to the affairs of the company. And given that the company itself is a fictional legal person, the directors are the individuals who the law entrusts with the running of the company's day-to-day affairs. The directors, of course, are not going to run the company by themselves in most instances. They hire competent professional managers. They may or may not be on the board. You may have a managing director, CEO, you may have someone who does the finance function, the CFO or equivalent. You may have a company secretary or compliance officer. You may have a legal head. Depending on the size of the company, you may have other functions. The point is, ultimately, all of these professionals have to do their job as delegated by the board, but the responsibility overall for the conduct of the company's affairs lies with the board of directors. Now, the duties of directors. There are some, and it's a very, very long list, which would practically take more than one session just to go through that. But there is a bunch of statutory duties that are set out for directors. Some of them are under our company law, which is our Companies Act. Many of them are set out under several other laws, which apply to companies depending on their size, sector, and other considerations. And in addition to that, through case law, there are a bunch of fiduciary duties that have evolved with respect to the expectation of directors' conduct. I can't claim to explain these duties effectively in a brief manner, but I'm still going to try. The best possible explanation that I can give of these duties is to run the affairs of the company in a manner that is responsible to all stakeholders. So who are our stakeholders? You have your shareholders, which is the first set of stakeholders. Second is employees. Third is creditors. Fourth is government. Fifth is also the environment. By the way, that's a sort of a legal requirement under our company. So you have to run the affairs of the company in a manner that is responsible to all stakeholders in to the best of your ability, in a manner that is consistent with applicable legal regime today. You don't need to be a lawyer for that. You just have to make sure you're the correct professionals or you seek correct legal advice. And you don't have to let your personal conflicts or any personal interest affect your duties towards the company. When I put it this way, it sounds like absolute common sense. So, but the law has prescribed, and this is a very, very, very short summary of what the law has prescribed. There are other sort of matters that the law covers. But in a nutshell, what the law expects directors to do is to deal with the company and the company's affairs in a responsible fiduciary manner, as if they were their own affairs, as if it was their own money, as if it was their own system, effectively applying the same level of responsibility. And again, doing it in a manner that is responsible to all stakeholders and not just one set of stakeholders, which is the shareholders or employees or any other stakeholders, but keeping interests of all stakeholders. Now, the next one that we can go to is duties of directors. What are these individual duties and collective duties? Now, what are the individual duties and what are the collective duties? Collective duties are nothing other than what I just set out, which is the duties of the board as a whole, which is effectively to run the affairs of the company in a correct manner. There is a whole bunch of compliances involved here, including to have certain meetings, to submit certain reports, to pass certain resolutions on certain matters. It's a whole bunch of responsibilities that the board has collectively. So then what are the individual responsibilities of directors or duties of directors? One obviously is the fact that they have to work together to accomplish the collective duties. But in addition to that, they have to disclose any potential conflicts of interest with respect to the company's commercial arrangements or affairs, disclose certain other matters with respect to other offices held by them. So there is a bunch of duties which are individual to each director, which are over and above the collective duties that they owe as directors on the companies. Now, directors per se, I've been talking of directors generally as a whole, but directors are of different types and their level of liability and responsibility towards the company differs based on the type of director we have. One type of director would be a director, the managing director or a whole-time director, or you have a few other names. But effectively, a director who's a whole-time employee of the company and is on the company's board. They are broadly referred to as executive directors. And they are the ones who are, as a legal matter, again, not getting into specific law, but as a legal matter, generally considered to be the first in line when it comes to any liability for non-compliance by the company. The second category of directors is effectively non-executive directors, but non-executive directors has two categories. One, non-executive directors are those who are not executive directors, which is effectively who are not in full-time employment of the company and not a part of the company's management. Non-executive directors may be independent directors. Independent directors, there is a whole bunch of tests. You are independent of the company's management, finances, affairs, etc. And second is non-executive directors who are not independent. Law sets out certain additional responsibilities on independent directors with respect to the level of scrutiny and the level of responsibility in relation to the company's affairs, in as opposed to, let's say, directors who are not independent, which is non-executive, non-independent directors. Executive directors obviously are the ones who run the company or any part thereof or any function thereof and stand on a very different pedestal. Now, the key issue and why, as I said, why are there complexities, is that not just does the law prescribe a whole bunch of duties on directors, and we've briefly discussed the fact that they may differ based on the nature of directorship, but also the fact that these duties come with liabilities. And these liabilities are both civil and in some instances criminal as well. So then I think there is a possible question that when you say civil or criminal, what does it mean? Now that depends on the law in question. And I'll take just a minute and explain the position under the Companies Act, because again, it differs on the law in question. Companies Act has hundreds of sections. Each of the sections involves some degree of compliance with certain set of requirements. And if you do not comply, the section sets out certain consequences. Each of those sections, and when I please don't hold me to it, there are over 400 or 500 of those, and there may be some which don't. But practically each of those sections actually set out a certain set of compliance or a certain reporting or a certain steps, set a certain set of steps that the company has to take. And if it doesn't, it says who is liable for the non-compliance, which is one, the company itself, and second, certain individuals. Those individuals change depending on the section and the offense. But in a majority of the cases, the Act uses the phrase officer who is in default. So the definition of officer who is in default becomes relevant. And in context of a company, an officer who is in default is defined to always include, without exception, the executive directors, which I had said a short while ago are actually sort of first in line for any non-compliance. Does it cover non-executive directors and independent directors? Yes, but it covers them in context of liabilities or issues that arose for issues that came to their attention, which is they came to their attention through board meetings, agendas, papers, etc., and to which they didn't sort of pay attention or they didn't do the need. So if there was no way for the non-executive or non-independent or the independent directors to have knowledge of an issue, and obviously negligence doesn't work. So let's say you should have asked certain questions, etc. But keeping aside specific factual nuances, the broad principle is if you had no knowledge and there was no reasonable way for you to have knowledge of a particular wrongdoing, then as a non-executive director, you ought not to be liable for at least the sections that say officer who is in default. And that's a bulk of the sections under the Companies Act, which actually set out liability for officers in default for any offense. Nature of liabilities under our Companies Act, there is one, monetary penalties. So there has been, as you may have read, a trend of decriminalization of these offenses. So which is continuing, which has been continuing for the last few years and is a welcome trend. But as a work in progress, there is a whole bunch of offenses which are now civil, where a breach involves payment of a monetary penalty based on an adjudication by an authority. But there are still some offenses which involve criminal liability. And the criminal liability can either be through payment of a fine. So not every criminal liability involves going to jail. In most instances, actually, it would involve payment of a fine. And in rare instances where there is actual willful wrongdoing, without now getting into what those circumstances actually are, is there a liability or a possibility for a criminal liability which involves imprisonment? Now, ultimately, your question will be that, or could be, that this is only another Companies Act. There are hundreds of other laws applicable. If any of you are lawyers or are so inclined, you can open most laws and there will be a section which is the heading merciful is usually standard, which is offenses by companies. You look at that and you realize that the laws have pretty much always set out what the standard and who is liable for offenses by companies. In most laws have fairly common standard language. Some laws have different language. But again, the general standard here is that the executive management or the person or persons in charge of running the company's affairs, which would be the executive directors in most cases, are actually liable. But in certain instances, unlike the Companies Act, most of these laws generally give the ability for the executive director to say that they were sort of not involved or were not aware or had taken all steps to prevent the commission of the offense, etc. And these laws also generally have language that any other, not just those who are sort of in conduct of the company's affairs, but also those who may be lower down the pecking order or other directors who were actually involved in the commission of the offense or due to his negligence, the offense occurred, can also be held liable. Now, we are talking of literally hundreds of laws here, and there are sort of several nuances to this language. But what I'm setting out here is at least the broad concept of the introduction of what happens under other laws for offenses by companies. There is, I think, three questions that have come in. I will address all three at the end of the presentation. Liability for investor reps on boards. Ultimately, it's going to be pretty much the same that I've set out here. But again, I'll address it in more detail at the end. How does an investor ensure the company is scaling responsibly and maintaining compliance? I think the answer is through effective oversight. But again, we can take it up in a little more detail at the end. And third is what key governance terms should be included in the term sheet? Great question. And I think it's best addressed once I cover the possible risks and mitigations for investor directors. That may answer some of these, and the rest I'll answer at the end of the session. But thank you. Great questions. I think we can go to the next slide. Yeah, thank you. Coming to the role of investor directors, the nominee directors, I think it's not, and when I say this in context of as a legal matter, the role of a director is the role of a director, which is effective oversight of the company's affairs, and depending on whether you are an employee of the company or not, your liability would change. But specifically in an investor director concept. What is the need and what are the key responsibilities that at least we've seen investor directors? The investor director effectively, and I'll cover the second bullet here, effectively has a dual role. One is a contractual role, one is a legal role. The contractual role is you are employed, in most instances, employed by the PE or VC firm, or you are a third party professional who has been contracted by the PE or VC firm to act as a nominee director on the board, as their nominee director on the board of the company. As a legal matter, and without getting into judicial principles and case laws which exist, as a legal matter, your role as a director and your liabilities as a director don't change if you are a nominee. You still have to take into account the interests of all stakeholders. You still have to do what is right. You still have to follow all of the rules and all of the liabilities and responsibilities that are associated with a directorship. The only addition here is that when you sort of file your forms, when you disclose the fact that this individual is a nominee director. So there is at least an implied assumption that the individual, in addition to looking at the company's interests, is also going to look out for the interests of the investor, which is the PE or VC firm who has appointed her or him on the board. As a practical matter, the investor or nominee, as a practical matter, it would be rare, extremely rare, for the interests of the investor and the interests of the company and its stakeholders to be at wide divergence. And frankly, it's pretty theoretical. So I don't think we need to address any sort of potential conflicts that arise in the role of a nominee director vis-a-vis the company and vis-a-vis their employer, because I would say, and at least in my experience, it has largely been that they are aligned. Because at the end of the day, the investor also wants that the company does well by its shareholders, does well by its stakeholders, and reputationally and otherwise is in a good stand. So ultimately, the nominee director's role on the board is to legally do the duties as a director and contractually protect the investment of the entity which is nominated, which is the PE or VC fund, which has nominated her or him. Now, there would be nominee directors. There could be nominee directors of lenders as well. But again, we are restricting the discussion here to nominee directors of PE and VC. Excuse me. Nominee directors, not as a legal matter, but as a practical matter, play a very important role in my experience, because most founders or individuals, entrepreneurs, people who set up companies, maybe young, maybe middle-aged, some instances older, but they often don't have the experience when it comes to a lot of the finer aspects on stakeholder management, on putting in place governance systems, on working and dealing with all stakeholders. And effectively, the focus of the entrepreneur, rightly so, is on the business. How to increase the business, how to increase my profitability, how to increase my market share, which markets to target. That is pretty much the focus of an entrepreneur or a set of entrepreneurs who set up a business, in which, looking at their vision, the PE or VC fund has invested. So what does the nominee director do? As a practical matter, they actually work, and an effective nominee director actually works as a very good foil to the founders or the promoters, because the founders or promoters focus on the hard business, the numbers. The investor director works with them, focusing on and coaching them, often giving inputs on putting in place systems and processes that are required for effective compliance and governance, on working with external stakeholders, and effectively on working with the company to not just focus on the hard business numbers, but on the softer reputational, compliance, governance, and other aspects, which enables the company's value creation journey, because ultimately that is the objective, to be more productive for all stakeholders. They also use their experience in coaching the founders to, in terms of, let's say, from a business expansion thinking point of view, risk management point of view, using their experiences in other countries and other portfolio companies, in telling the founders that this is what we would advise you to consider or do, given where sort of the business is, where the sector is, where the larger macroeconomic situation is, and using their network, which is effectively network of their peers, their other portfolio companies, to try and help the company's business grow further in a product. So effectively, the role of a nominee director is dual, which is as a director to do what a director is expected to do, but as a nominee to also work towards overseeing the company's sort of operations, coaching the founders and entrepreneurs, and working towards value maximization. And again, depending on if the company is not doing well, or if they have a reason to believe that the founders are sort of doing something they should not be doing, then you may also need to act a little tough. You may need to act as a watchdog. The point is, depends on the company's board you are on, what tone you take, what does the company need at that point of time. Keeping in mind the fact that you have both a legal obligation or liability and a contractual responsibility to your investors and to your employer. Now, ultimately, I've addressed to a large extent even the third bullet, which is navigating complexities and balancing interests. There is unfortunately no one answer to this. It is necessarily fact-specific. You have to be able to look at. So in this case, what I sort of like to say is you have certain principles that you need to keep in mind, which is KYC, KYB, and KYM, which is know your company, know your board, know your management, and one more KYB, which is know your business. You as an individual, as a qualified individual who's working with or contracted by the PEVC firm as an expert who's in the sector or in the company's operations, who's on the board to represent their interests, should be able to look at what is happening, look at the numbers, look at the management, talk to the employees, get a sense of where the business is going, get a sense of what is happening, and adjust your level of guidance, tone, tenor, level of interference, interference is the wrong word, level of involvement, which does not tantamount to interference unless you really need to interfere. You may need to in certain instances, but level of involvement, it needs to be put together in a very, very fact specific and a company specific. What works for company one is unlikely to work for company two, and what works for company two is unlikely to work for company three. So you can't have one checklist on what is to be done. You have to keep in mind the fact of your dual role. You have to keep in mind that you need to balance the interests of your employer, the company, and its stakeholders, and ultimately do or advise on doing the thing that is right by all key stakeholders. That ultimately is what it means by balancing the interests. The key principles here are both legal and practical. To a large extent, I have covered all of these in my earlier comments and I'm not going to repeat it. But the one overriding principle is that ultimately you cannot be in a position where for any practical considerations, you take a legal risk that at least you have not obtained advice. So ultimately, if you are in a situation that is legally tricky, if you are in a situation that is legally gray, depending on whether the circumstance is such or the sector is such or any other development that has occurred, as a director, the one thing you should never shy away from, and I say this at the risk of being accused of conflict of interest because I am a lawyer, but the one thing that you should never shy away from is obtaining independent external legal advice. There are genuine liability issues for the company and for board members, including you if any of you are a board member, with respect to the company's operations and affairs. So please keep in mind the fact that, and you are in a scenario and environment today, and you are reading about it, where there is enough enforcement by statutory and regulatory authorities against who they consider to be wrongdoers, which in some instances also includes state. So turning a blind eye, negligence isn't practical. It's inviting liability on us. Practical considerations mean keeping in mind the various interests, understanding the risks, understanding what are the possible issues that can come up, and then advising or taking decisions depending on what you need to do at that time. That's the reason why the practical here comes after the legal and not before, which is effectively to first understand what the legal position on a particular issue is and then take a decision based on your specific facts, your specific circumstances, which actually best serves the interest of you. I think that's it on the role of the investor directors, which is on the nominee directors. Ankita, we can move to the next slide. I think there's no more question. I'll again address them right at the next. Yeah. Yeah. So I think the next one is now on the risks and liabilities and the mitigation strategies. The risks and liabilities are several, and frankly, I can take a lot of time on those. But ultimately, they arise from the four key heads that I've set out here. One is business failure. Now, you may question business failure is usual. What are the risks and liabilities that arise from that? But depending on the nature and extent of business failure, for example, unpaid salaries, unpaid taxes, or unpaid statutory dues, unpaid vendors, they may choose to sue you in addition to the company. They may choose to sue the investor. They may choose to sue everyone to try and make sure that they get the money. So there is possible risks and liabilities arising from business failures, from fraud or wrongdoing. I think this is a very sensitive one. So if management or has engaged in any fraud or wrongdoing, ultimately they are liable and not you. But then if that comes to your attention, you need to take steps and you need to obtain legal advice on what is it that the company should do vis-a-vis the individuals who have engaged in such activities and vis-a-vis its business and operations. Third key area of risk is disputes inter se between board and shareholders. This is an underappreciated area of risk, but this is a fairly huge area. One area that often arises if there is a conflict or a clash between the investors and the management, or God forbid, a clash among investors if there is more than one investor, or a clash among all stakeholders on the board. That is a bit of a nightmarish scenario, and that can actually lead to liabilities on everyone because decision making gets paralyzed. Next is risks, and this is a black swan event, which is if there is a regulatory or policy change which leads to risks and liabilities on directors. That is not something that you can do anything about other than address it when it arises. Now, in what circumstances are nominee directors liable? Because ultimately, when you think about it, and when you think about navigating the complexity at a PEVC-backed company, if you are on the board, the first question that you're going to think, even if you are extremely loyal to your employer, is what is my life? And the next question that will come, or at the same time, the question that will come is, how do I protect my employer's interest? I think to those two questions, and those two are correct questions. But the third question that should always come is, what is it that I have to do vis-a-vis the company in my role as a director? Because ultimately, that is what more often than actually determines if you are liable, when you are liable, and how. If your guiding principle with respect to in a difficult circumstance vis-a-vis the company or vis-a-vis its operations or vis-a-vis other stakeholders, ultimately to ask yourself after obtaining external advice that you consider necessary is with respect to my role on the company, both as a director and as a nominee, what is the best course of action that is compliant with law and takes care of stakeholder interests in the best possible manner in these circumstances. If you follow that, can you be sued? The answer is yes. Directors can be sued at any point of time. Can you be hauled through an investigation? Again, the answer is yes, because investigating authorities may choose to investigate anyone. But ultimately, would you be held liable for wrong? If you have followed this principle, I believe that it would be extremely unlikely that you would be held liable for wrong. Because ultimately, that is your role as the nominee director. Things go wrong, as they always will. And when things went wrong, if you were in that position, or before things went wrong, when you were in that position, did you take the necessary steps? Given the context, did you, for example, just giving a very simplistic example, if you have invested in a company, instructed the management to put in place a proper framework for prevention and detection of fraud and wrongdoing, invested some resources in putting up an internal audit function, and ultimately had in place a framework that for a company of the size and scale that you are invested in and are on the board is appropriate for preventing and detecting frauds, accounting misstatements, and wrongdoings. Now, despite that, if one of the key business officers actually siphons money from the company in cahoots with other employees, can you be prosecuted, or can people say you didn't do enough? They can always allege. But if you are able to prove through the minutes of meetings, through your emails to the board members and the management, that you had actually instructed to put in place and oversaw the putting in place an effective system, and ultimately whoever did wrong in their individual capacity, and they did wrong despite the systems and processes and not because of lack of systems and processes. The legal position is fairly clear, at least into my mind, that you aren't liable. You may still be investigated, but you would not be held. That's a simplistic example, but I'm just trying to say, but if you were on the board, you didn't bother, you didn't come for board meetings, or even if you came for functionally, you were trying to do three other things during a board meeting, you didn't come, you didn't read board papers, or you didn't insist on board papers, you didn't insist on an agenda, you came unprepared, you simply attended, listened to management and said, thank you very much, I have other important things to go to. That is a recipe for disaster. When things go wrong, that is ultimately when you could be held liable because you were simply negligent in performance of your duties. So that answers the last question here, which is steps to mitigate risks and liabilities, which is effectively what I just said, which is actually do your job as a director and as a nominee. Attending meetings, reading papers in advance, asking for papers in advance, not encouraging any sort of, obviously sometimes you need ad hoc discussions, but not encouraging ad hoc discussions during meetings, coming prepared, asking the right questions, asking basic common sense questions if nothing else, maintaining copies of documents that have come your way. If you see a concern, to highlight it clearly and adequately and ensure that it is minuted. And if it is not minuted, because you're not the chairperson, you can't decide on what goes in the minutes. Ultimately, you put a documentation and email to the company to say that these are my concerns and I would like them to be addressed adequately. To understand the business, to understand how the company makes money, and to actually be able to understand the risks in context of the business. Not to approve anything that comes to you functionally saying, oh, the managing director has seen it, I'm okay. To actually apply your mind. Or if you don't have the time, at least assuming you're from a firm and if you have a team, that they have actually looked at it, you worked with them, you looked at it, and then you come in and say, fine, I'm okay or I'm not. But ultimately, having seen what comes to you for approval, having taken the effort to put in place policies and procedures, if they don't exist, and if they have, then to actually look at them and to satisfy yourself that they are reasonably sufficient for a company of the size and stature that you have invested. And lastly, again, this is for your interest as individuals, to evaluate the adequacy of the insurance coverage under D&O, which implies that the company should have a D&O. And second is that to evaluate what is the extent of indemnification available from the company to you to act in your role as a nominee. That is broadly, among many others, the key steps to mitigate steps and minimize liabilities that may come your way in your role as a director. Now, there are enough real life examples of where things have gone wrong, which are public, but there are enough real life examples of where things have gone right and thankfully are not public. And what I can tell you is based on my experience. There are many, many, many more real life examples of things that have gone right because people have simply done their job. And they are able to show that they have done their job with respect to being on the board of a company where things have gone. So ultimately, my sort of concluding thought here is, now I can't claim that this is sort of a complete runaway on what you need to do with respect to being on the board and navigating the complexities of being a nominee director on a PEVC-backed board. But if you are able to, in your mind, based on what we've discussed today, and as you grow and have further experience in life, set out your own set of principles that cover these issues and are able to, hand on heart, say that what I have done was to the best of my ability, and I have done to my knowledge, and I have done whatever it takes to make sure that I perform my duties. Things will still go wrong, but I think you should be able to say that I can't be held liable for anything more than for anything else, because my job was to act as a nominee director, and I have done so, in utmost good faith and without negligence. I think that's broadly it with respect to the presentation itself. There are 4 questions on the in the chat box, and I'll address these one by one. I think we have 5 minutes left, so I think that's good enough. First is, what key governance terms should be included in the term sheet? I think the answer is, fairly simple. One, board representation. Board representation, observer rights, audit rights, inspection rights. These are standard, and if there is anything more, depending on the sector or the scale, they may be there, but these are, I think, generally the bare minimum that you would think from a governance point of view. Second is, how does governance change when a startup is preparing for an IPO? And when does the company start preparing for it? Again, great question. Governance does not change when the startup is preparing for an IPO. Governance actually multiplies, because when you are thinking of a drop of public money, which is effectively what IPO is, your compliance requirements multiply manifold, and your entire way of thinking of how the board should function, how the business should function, and how we should govern our business going forward would change, and at least in my assessment, change materially if you are thinking of going public and taking public money. When should the company start preparing for it? I think it depends on how prepared the company already is. If you're talking of a 10, whatever, 20, 25% organization, lean organization with a couple of investors, one investor nominee director on the board thinking of going public with a very lean sort of compliance and governance function, it's obviously going to take longer than a mature business. You're talking of hundreds of employees, already a well set compliance function, and understands the sort of compliance role and responsibilities. And so it depends to a large extent on where the company is. So it's not a question that I can answer abstractly, but I think the only answer I can give you, which at least makes sense to me, is it depends on where you are right now. Sometimes it may take much longer, and sometimes it may take nothing. The third question.
Prerak,
Yeah.
just a second. Just before you get on to the next question, can we just take a few minutes to launch the poll?
Launch the poll. Sorry.
Yeah, it'll just be launched now.
Sure.
It'll take 1 minute.
Sure.
And we also have a few questions on the chat, if you're okay to take them.
I think there were two left. So I have addressed two of them.
Yeah.
So I think there are two left. So I think I'll take a couple of minutes and I think that will be the top of the hour as well.
All
The
right.
first is, what recourse would a director have if an investee startup fails to repeatedly meet directives given by the board? I think the answer is several, because if you are the board, you have the ability to change management. Depending on your shareholding, you have the ability to again change management. You have the ability to raise funds. Again, depends on the contractual framework. So, for example, if you are a board but you don't have any rights under your shareholder agreements, then the answer is a bit different, as opposed to you are a board with majority shareholder. But ultimately, the director individually needs to make sure that the board, through minutes and through records, is aware that the board directives have not been followed by the management, and the board as a whole needs to take corrective action, which may, to the extent possible, include replacing management if board directives are not followed. Now, there may be certain sensitivities here. You may need the management, you may want them to cooperate, they may not be cooperating. So in such cases, the answer may be a bit more nuanced. But I'm saying in terms of available remedies, there would be several. And unless you have a really sort of one-sided investment contract, which is in the management's favor, that you can't do anything, in which case, as a board, I think you still have the ability to tell the management that if you don't follow our directives, we will be in a position, we will not have an option but to inform the government that the board's actions are, but that the board's directions are not being followed. So as I said, you will never out of options with respect to acting against management. It depends on what you need to do in a given context, depending on your objectives and the specific facts of your case, including the nature of the management, the nature of your investment, and what is it that you seek to achieve at the end of it. Lastly, liability and responsibilities of an observer. Now, that's a great question. If you're not a nominee director, just an observer, which is the trend nowadays that some PE and VC firms have taken, you have no legal liabilities or responsibilities as an observer. It's only contractual. But that does not mean that, so if you are attending board meetings, participating actively, giving lots of inputs, you can still be called by government authorities if there is an investigation tomorrow and be asked to give evidence. But if you are not a director and you have not been acting as a director, but actually acting as an observer, then as a legal matter, there is no liability on you as such, which would affix itself to a director. So I think with this, I have addressed all the questions that I can see on the board. But if there is something I have missed, please let. I have answered, I think, governance changes on IPO. I have answered recourse to a director if investor startup fails to meet directives, and I have answered on liabilities and responsibilities of board observer. So I think, Ankita, this is it based on what we have right now.
Yeah. I think all the questions have been answered. Thank you everyone for joining us. We hope you found the session useful. And thank you to our trainer Prerak for such an insightful session. Requesting everyone to share your key takeaways of this session over social media. And you don't forget to use the hashtags, hashtag Winpe and hashtag Winpe Ignite. And also don't forget to tag Winpe. Join us at our annual Winpe Leadership Summit and Awards WLSA for the PVC industry on March 20th. We'll share the registration link on the chat box, which you can also find on our website. And once again, do join the Winpe Ignite WhatsApp group to keep yourself updated on more such sessions, job openings, and also third session of the masterclass is coming up next week on Friday, 28th of February. Do share it with your peers as well. And do join our database that we share with our member firms to support their hiring processes. We'll share the link on the WhatsApp group. See you everyone on the next session. Thank you, Prerak.
Thank you, everyone. Pleasure. Bye-bye.